Perez, and I am AARP California State President Emeritus. How are you, everybody? Thank you so much for joining us. Oh, I think we need to mute some people, but let's see. Well, it's my pleasure to welcome you to our last This meeting is being recorded. All right. If you haven't muted yourself, please mute yourself. So thank you so much to everybody. It's my pleasure to welcome you to our last Let's Talk Dinero with AARP, our last conversation of the year. We know that you've worked hard to build what you have, you saved, you managed it, and now it's time to plan for what's next. Our session today will provide you with information on how to secure your estate and encourage you to have those planning conversations with your loved ones. I'm sure everyone here knows of families that have been torn apart by arguments or had a lot to pay or were just overwhelmed with the process. So thank you so much for joining us because AARP is here to help. As always, we bring experts to guide our discussion. Today, we have Yvette Cuyate, and Yvette has dedicated her career to empowering others with sound estate planning that protects their assets and their peace of mind. She is CEO and founder of the Cuyate Law Group based in San Diego. But before I turn over the program to Yvette, I'd like to take a quick poll so she knows who is here with us today. Simple question. Do you have a will in place? Let's see if my AARP colleagues could launch the poll, please. I just want to know from people or put it in the comments or chats. Yeah. Let us know. Do you have a will in place? It's almost a 50-50. Just let us know. Do you have a will in place right now? All right, I'm going to end the poll, share the results, and it's a 50-50 split. Not a problem, really. Just the fact that you're here with us today is a huge win. So thank you all for joining us. Thank you for your responses. A quick reminder, this is a chat for you. It's meant to help you. So please submit your questions in the chat box. If you're watching us on YouTube, please submit your questions in the comments. So, let us know anything, that is on your mind. We have the expert here for you. So this is your time. But now let me turn over the program to the real expert in the room, Yvette. Bienvenida, Yvette. Welcome.
Thank you so much, Patricia. It is my pleasure and honor to be here with you again. Happy holidays to you and the AARG staff and to everybody else that's watching us. All right, so I'm going to go ahead and share my screen so everybody can see the presentation for today. And bear with me one second.
Just minor little technical delay. She has a lot to share, and you're going to appreciate, her taking her time. While you're doing that, Yvette, while you're putting it in presentation mode, want to let people know that there's going to be a lot of information coming your way. Don't worry about it. If there's anything you missed, this session is being recorded, so you'll be able to view it later. All right, Yvette, take it away.
Are we good to go? Can you see it okay?
Yes, we can.
Great, wonderful. Well, thank you for being here. Again, thank you, Patricia. We got a lot to cover. I'm going to try to cover everything that I can in this. I think you said there'll be room for some Q&A, correct? Okay.
Yes, I'm nodding yes.
All right. So yes, thank you for having me. I appreciate being on today. It's not about me. Today is about you and getting everybody on here educated on everything that has to do with estate planning. I'm going to demystify some things. I'm going to explain some terminology, and hopefully at the end of this, whether you were in the 50% that said I have a will or the 50% that said I don't have a will, you'll walk out of here a little bit more empowered when it comes to estate planning because there's a lot of terms out there. All right. So first thing I want to ask you, and you can put it in the chat, right? If you see these different pictures, what do they all have in common, right? And I kind of gave you the answer a little bit, but they're all part of your estate, right? A lot of people think, well, I don't have money. I don't really need, I don't have an estate, but you have loved ones. And that is the most important thing when it comes to planning are your loved ones. It's planning for not necessarily when we think of estate planning, not just our death, but our incapacity and planning for their future. So yes, it's your vehicles, it's those airline miles, those digital files, the cryptocurrency, your health, but your loved ones, right? So estate planning, I want you to think broader in terms of why do I need to plan? Okay. A lot of these terms, I'm sure you've heard of them. Again, by the end of today, hopefully you'll know, well, what is a trust and a living will? What are the differences? Why do I need to think about my property disposition? What options do I have with charities and life insurance? How does this all tie in, right? Because it all does tie in as part of having a solid estate plan. All right, but first, I want us to kind of, be honest, because a lot of us grew up with a lot of these misnomers, a lot of these, concepts. We grew up with thinking, money doesn't grow on trees, right? We got to pinch our pennies or save for a rainy day, or we just can't afford it, right? And I really want to challenge you to put these thoughts aside because we really do need to think about this as an investment for our loved ones, for us, for our future, when it comes to the planning portion. So, if you want to throw some in the chat, what are some of the things you grew up with? I know my grandma and grandpa, they kept the money in the colchon, right? They kept the money not in the bank, which was not ideal, right? They didn't trust banks.
Under the mattress.
Under the mattress, right?
Yeah.
Or in jackets, or whatever, what have you. But these are just some of the things that, to be honest, in our community, we do have some of these that are passed down culturally. So I want to take that and just kind of put those aside for today because I really want to educate you on the importance of this. And I find that these mentalities sometimes they get in the way. They get in the way a little bit, okay? So let's get into some of the myths out there, right? And I said one of them already. Myth number one, it's just for people that are rich. I get a lot of clients that tell me, oh, I just have la casa. I just have my house. I just have this. I don't really have anything. And then I dive in and I find out that they have 10 grandchildren and multiple properties and properties here and in other countries, right? And they actually have a lot more than they think they do. Or they tell me, well, I did it. Those of you were in the 50% that said I have my will. I did it and it's done. And I wish that I could tell you that that's true, but the thing is, it's like a car. You have to get it maintained. So you do need to update certain documents, right? There you go. I have a will. I'm good. I'm going to challenge you. We'll see after I educate you guys a little bit on will a will suffice, right? And we'll talk about that in a minute. How about this one? We live in a digital age, chat GPT, Zoom online, we can get anything, information, I can just do it myself. And I tell people this, all the time is if you are going to do it yourself, please have it reviewed by a professional, at least. My dad taught me how to change car tires and change my oil before I went to college. I can do it, but I'm not going to do it. I'd rather pay somebody because I know that that's just not something I want to risk. I don't want to make a problem worse. There are certain things that you want to just leave to an expert, and your estate planning should be one of those. How about this one? Oh, it's just all going to go to my spouse anyway. And that might be true, and that might be fine for you. But for my families with blended families, with, some trust issues, that might not be what you want to happen. And so there are reasons why you might not want that. You might want to have a different agreement with your spouse, and set that agreement in writing. Okay, so those are some misconceptions. So let's get
And
into which one
sorry,
should I have? Yeah,
Yvette, the other one is that you assume people know what you want, right?
correct.
That people know you. My husband, obviously, my kids would know what I want.
Yeah,
So,
yeah,
yeah,
right.
absolutely.
Yeah, I mean, my husband sometimes he still doesn't know what I want for Christmas, and we're about a week away. So,
True.
right, that's my fault though. But yeah, that's one. All right, so should we have wills or trusts? So let me explain the differences to you. A will acts as a set of instructions for a judge to decide if it's valid. I said keyword is judge. That means court automatically. So a will needs to go through probate court for a judge to decide if it's valid, and then set up an executor and set up an administrator. So yes, it's less expensive. It's easier to complete, easier to administer if it's not contested. And these are, a will is where you will name a legal guardian. For those of you that have children or grandchildren, this is important to know. So you need to have a will, whether you're in that 50 or 50, this is why you need to have it. But again, going back, what it does not do is it does not keep us out of probate court. Just how there's family law court, criminal court, civil court, our judicial system has lots of court. Probate court is the court that administers the process to settle your estate after you die. And if you know anything about court, is nobody likes to go, attorneys included, even though we're paid to go, right? It can be time consuming. It's very, very expensive, and it's public information. And I'll get into that a little bit, why that might be a concern for some of my folks out there. But just if you have a will, and you only have a will, this is good to have at least. But you need to consider, in addition, maybe a revocable living trust. So you'll hear living trust, revocable living trust, those terms interchangeably. Some states, have just little variances of those. But for here, I'm talking about the most basic trust. Revocable meaning that you can change it during your lifetime. And when you think of a trust, I want you to think of like a intangible safe deposit box where you put your assets in it. The trust holds everything. You transfer your assets into your trust, and the trust holds it. So since you do it in your lifetime, there's nothing left for a judge to do when you're gone, because the transfer, what we call the funding process, that's already been done in your lifetime. The moment you die, your spouse or whoever, they will take over the keys, and now as trustees, they will administer it according to your wishes. And so because you already designated and you've left them the keys, there's no need, and you're not subject to probate if it's funded correctly, meaning if you've taken the time to make it, but also retitle things accordingly. There are some tax saving loopholes and potentials there. We use it a lot for generational wealth planning. We love it because, again, no courts are involved. Anytime you don't have to deal with court, people have less headaches. And there's nothing worse for families to be grieving somebody and also now be dealing with family problems, misunderstandings, people that come out because now it's public knowledge. That our family member has passed. So it's quicker, it's much easier to administer. But yes, it is an investment. And if you don't do it and keep the maintenance up, that can be problematic. I have people that tell me I did my trust in the 70s, but they've now bought another home or another property, and they've never taken the time to fund their trust with their assets. So it's only as good as the maintenance. That's what I tell people. All right. So that's a trust. And there are other types of trust, but for today's sake, right now I just focused on that one. So there's 4 key documents, whether you decide to have a trust or not, that make up your estate plan. Everybody over the age of 18 needs to have these 4 key documents. The first one is a will. And again, I explained that one already. It identifies who the guardian of your kids are, who's going to be your executor. You need to have powers of attorney, because this is where we get into planning for our disability, our incapacitation, not necessarily our death. So if I get long-term COVID, if I get in a car accident and I'm in a coma, I'm a business owner. I need somebody to be able to pick up that power of attorney and keep my business running, the day-to-day operations. Just because I'm married, that does not give my spouse a financial power of attorney or a power of attorney over my medical decisions. Like you said, Patricia, your loved ones might not know what you want. And so this medical power of attorney, which we call an advanced healthcare directive, or some states call it a living will, you designate what your medical decisions would be if you can't speak for yourself. So there's no guessing, and there's, more importantly, no fighting. If I'm in a coma, my family knows, do I want life-saving measures? Do I want to be an organ donor? Do I want an autopsy, right? Where do I want to be laid to rest? And that spells everything out. That way they can just follow my wishes without the extra stress of trying to guess what she would have wanted. Again, my husband, he's going to try to guess what I want for Christmas. We'll see how it goes, right? I don't want him trying to guess for what I want medically. And then because we live in this country, we need to that needs to have a HIPAA release form, so that your medical agent can act. And really quick, I said everybody over the age of 18, understanding that those of us with kids in college or young adults that have, as children, they've left, if they're gone and out of your house and they have a medical emergency and you're somewhere else, the medical professional that is attending to them doesn't care that that's your baby. Medical decisions can't be made by you unless you have this. So it's very, very important. That should be part of our planning. Again, we're talking about globally for our family, our loved ones. Just this summer, my daughter was badly burned out in Virginia in a house fire, and she's now 18. We literally lived this firsthand. If we didn't have these things in place, her dad's out here in California, we don't have access to her medical information to advocate for her. So these things are really, really important. So it's not just for when you're old, it's you're 18, you're leaving the house, great, let's get these in order, right? So I leave this back to here. So what you want to decide is, again, should I have a will? Should I have a trust? Well, what do I want my family to go to probate court, right? And those of you that are visual learners, here's a good visual representation, right? A will is just, again, I'm going to say it again because I really want to put this in your memory bank. A will is a one-way ticket to court. You're going, right? And think of this as it's a guarantee, because things can't be administered without court. A trust, think of that, there's that safe deposit box for my visual learners out there. All right, so there you go. A little bit more visual representation. I have nothing, I have a will only, and I have a trust. I like to think of this as, there's good, there's better, and then there's best, right? Best planning. And I liked what, a lot of people say, well, what's good about not having a will or trust? And I tell them, well, we live in a country where we have rules and regulations. That means that we have a legislature that has sat down and written out a will for you. It's called the probate code, right? It's better than nothing. It's better than your family fighting for years and years and years without any decision. So that's good, right? Better, of course, it's having your own wishes, not the government decide. So better is having a will. Best is having a trust and we're out of court. We're not visiting court. Family can grieve in peace without the fighting and all of that. All right. Let's talk a little bit about probate court because I think I've raised a little bit of stress here with it. You know, I already told you, what is it, right? Well, it's the process. It's just the court administration process of what the state law saying who gets it. Um, but let's talk about what it actually costs because a lot of people aren't too aware when they think, well, you know, that's fine. My family will go to court. So let's think about it. You have to pay to file the petition. You have to pay attorney fees, which are set by the probate code. By the way, we don't make them. If there are problems with your estate, meaning we have to sell something, we have to fight something, there's more fees, right? We have to potentially do a probate referee fee and bond fees and a final petition. So you're looking at least for an average estate, okay, you're looking at least about $24,000 just in attorney's fees. And I say pain and suffering not included, because this is what it's going to actually cost your family financially of your hard-earned assets. And mind you, while this is happening, everything is frozen. You can't sell the house. You can't get into the bank accounts. You can't do certain things to move this around. So this is what it actually will cost. And it's contingent, again, on the value of your estate. The 24,000 that I gave you is just thinking about a house or the estate about the size of $500,000 in California, which we know right now is much higher in other states, you know, up and down. So we're going with that number just to give you an idea. All right, of what it costs. Okay. So if you live in other states, let's look. So California, maximum estate values to avoid probate. If you have an asset over 150,000, guaranteed you got to go to probate. Compare that to New Hampshire or Georgia, where if you have $1, you're going to probate, right? So the reason I bring this up is because people tell me, well, I don't have anything, or maybe I just have this little checking account and we'll do a small probate, simple affidavit to try to avoid the long, complicated probate. And that's fine, but it's not always guaranteed. I see a lot of times where banks will still hold on to assets, not release it, freeze everything until there's an actual order. Even though our regulation says this, our state laws and banking financial institutions don't always talk to each other. They have internal regulations that they need to follow. So take this with a grain of salt. But yes, if California less than 150,000, you would technically be exempt from probate, God willing, if you can get past the red tape of whatever financial institutions you have to deal with. Okay. All right. So I'm going to take a step back and talk about why some of these professions might not want to have their information out there in public record. And these are just some. There may be others that you may think of them, but those are my service categories, right? So law enforcement, therapists, teachers, correction officers, certainly doctors, lawyers, right? Those of us that have deal with the public. You may not want your probate case open to the court record and everybody that you maybe put into jail or served in some capacity know who your family is and where your assets are. That could be very scary. So that's one reason. Forget the money and how much it costs. Privacy is a huge concern for some people in specific professions. All right. What about what does this got to do with anything, right? Those of you that have children, right? And I will tell you right now, my husband and I, a blended family, we have all girls. And I hope they marry wonderful men that are godly men and, you know, take care of them and provide for them. But what if it doesn't go that way, right? I want to make sure that my trust that I set up protects them from them maybe marrying the guy on the left, right? I don't know. So this might be a concern for some of you. You know, my husband and I say we work very hard for them, but not for their spouse, right? And this can go both ways. I'm being a little bit gender, and neutral here, but it could go both ways. I've also seen it where if somebody has a sizable estate coming and it's not in a trust, that could potentially try to be used against them in divorce proceedings to try to get out of alimony and stuff like that. So just something to consider. With a trust established, you have a little bit more say and a little bit more protection you can set up. All right. I'm going to go um, a little bit quicker on these ones. These are just some reasons or family dynamics. We know that families don't come in one size fits all. For our Latino families, we often live in that sandwich generation where we have caregivers at home and little ones. Maybe you have parents that are aging and are with you. This might be a concern. Maybe you have kids or loved ones with special needs that are receiving government benefits. And so you might want to think of special needs trusts for them. And so, it's other things like that. For those of you that are in my categories of, high propensity to be sued, right? So if you own rental property and you have tenants, or if you're lawyers, doctors, those professions, there a trust is not let me be very clear. It's not an asset protection, a revocable living trust. There is what's called a California homestead exemption that would allow you to save a part of equity in your home. But a trust is a way, like a level one of setting up an asset protection game plan so that if you are sued, your assets aren't out there with the red bullseye for people to come and try to get. Um, so really quick story on that. I used to be a litigation attorney. Mom lets teenage daughter gets in a bad car accident, insufficient insurance costs. Guess who they're coming after? They're coming after mom and mom's house for the litigation. Okay, so these are just things to think about. Um, 401ks, your money, right? Keeping the cookies in the cookie jar, keeping them protected, right? Not just the home, your other liquid assets too. For a lot of Latino families, La Casa is the 401k. That is the pride and glory. This is what our parents strive so hard to build and leave behind. And there are certain capital gains considerations and property tax reassessment landmines if we're not careful that we can trigger by just gifting our child the house outside of a trust. So I want you guys to really think about that for those of you that are inheriting, make sure that you do it in a way that you're not going to end up paying the capital gains taxes from when mom bought the house in 1970 all the way to 2025, right? You want to get that step up in basis so that you avoid that, right? I'm teaching you the things that are legal that the rich people know are very well aware of that they do, okay? So this portion, the Medicare portion of why we want to think about establishing a trust well in advance of maybe needing to be on Medicare, Medicaid, is really important because there is a look back period. And the only reason we would do certain things like this is to make sure that the type of trust we're using for this planning is done correctly. It's done in advance. And this is not your normal revocable living trust. This is your irrevocable trust where you're protecting your asset, your major asset from the government law that says that they can come and seek reimbursement for long-term care costs that they put out or that they give you if you are on one of these programs. So I love this visual because it's a good representation of just, what we're doing with this. Again, this needs to be done in advance. It's not something you can rush, and it's something that we need to plan out very well. It's not for everybody, but I just want to let you know this is something that is out there that is an option. Okay. And your life insurance, right? Why does life insurance have to do with this? Well, I said a little bit, right? There's a long-term care component to life insurance nowadays. And for my folks that are needing long-term care needs, they want to make sure that if we can avoid, again, good, better, best, if we can avoid having to use a government program and we have our own independent long-term care policy to cover some of those long-term care needs, that's better. That's the best type of planning that we can do. But sometimes we can't get there, and so we didn't plan ahead. So we may be having to rely on Medicaid, something like that. So we want to, okay, if that's the case, go to maybe an irrevocable trust or do some other sort of asset planning. Okay. Um, but that's where the life insurance part plays in with the long-term care planning. We want to make sure that our kids aren't burdened with the cost. This is the latest data that is out there right now. This is the 2023 numbers. And just to give you an idea of what nursing home costs, it's over $13,000 a month in California. In Virginia, over $10,000 a month. And that pretty much fares across the country. We want to think about our children. Okay, they may not have an extra $15,000 a month to put me in a nursing home. What are the things that I can do to, number one, avoid that financial burden on them, but also importantly, protect my asset that I worked so hard to get from being recouped in a government repayment program after I'm gone. So I want to leave it for my children in the end. Okay. And along those lines, the other thing that we need to think about is really, does my estate plan work? Right? Does it work? Because any estate planning attorney can make really great binders with the legal stuff, but at the end of the day, I want to know, did we meet the goal? Are you going to be able to retire, stay in your home, not burden your children, and stay retired and have that reliable income? So I work a lot with other financial professionals that are able to put together a plan. The estate planning, it's not in a vacuum, it's not insulated. There's a lot of levels to it. And you certainly want to look for somebody that can have these connections with trusted people that can help you put together a plan where you'll be able to do this. All right, that is the goal. Because if we're talking about La Casa, I don't want to see you have to sell La Casa because you don't have enough money to retire, or now we're trying to sell it to put you into long-term care. That's not the goal, right? Okay. So I'll leave you with this. Again, my visualization, right? Do I need a will? Do I need a trust? It's up to you. But now you know, now you're equipped with what the differences are. You know the two avenues that you're going to go. I'll leave it to you on what you want, what you think is best for your family. And I'll leave it there.
All right. Well, if the goal was to scare the bejesus out of us and this being a wake-up call, mission accomplished. We certainly know what we need to do. For those of you who just joined us, welcome, bienvenidos. I am an AARP volunteer. I'm Patricia Perez and serve as AARP California State President Emeritus. And you just heard a presentation from Yvette Cuyate, and she's an attorney and helps, of course, estate planning. This session is being recorded, so don't worry if you missed any part of it. Later, you'll be able to view it. And there's a lot more information coming your way. So, Yvette, already a lot of questions. This is your chance, of course, if you're watching, your chance to ask questions, submit it in the comments or in the chat. We'll get to as many as we can. But don't worry, we'll have other sessions in the future, other Let's Talk Dinero with AARP events. So this is not the last conversation we'll have about estate planning. Well, now to the questions. One is that somebody set up a family trust long ago in 1995. Now there's grandchildren. If the person and the wife passes away, do they need to create now a new trust, including the grandkids, or can they just amend what is already there?
If the original people that made the trust, we call that the grantors, if they have passed on, it is now irrevocable. You cannot amend it. So whatever their wishes are or were before they both passed, those are the wishes that need to be carried out.
So if there's new grandkids, you need to create a new trust or amend it while you're still alive, correct?
Correct. Yes.
All right. So if you already have a trust, and I think it was 50-50, right? People who, it was a will. The question was a will. It was a will. So this is your chance to do a trust. But if you've had it for some years, like Yvette was saying,
Yeah.
like a car, right? Everything needs to be maintained and updated. So, right. Somebody had a question also regarding changes that how can they prevent the children from having property taxes reassessed upon their death?
Yeah, so that question is referring to a 2021 law that just got passed. If I'm assuming the person's here in California, it was passed here in California. And like I said, there's some landmines that can be triggered when the properties are transferred to a child and the child decides they're not going to live in it, etc. So my advice is you need to get with a professional to assess your specific situation, what the kids are going to want to end up doing so that you know in advance what your potential reassessment may or may not be. There are some exclusions, but that's for like a whole other presentation. But definitely get with a professional before that happens.
If that many of us, for example, on insurance policies that ask for beneficiaries, on accounts that ask for, benefit, I mean, would the trust kind of, oversee all of that, or how would that work? The trust with all these other beneficiaries that we have
Yeah.
listed.
So ideally, we want them to mirror each other. But when it comes to retirement accounts and life insurance accounts that are specific to you as a person, you cannot retitle those to your trust. So you can leave, however, the trust as the beneficiary, and then the trustees will administer according to your wishes. If it is a like a 401, not 401k, if it is something else like a money market account or an investment account or something like that, those you can retitle to the trust directly. And so now the trust owns it. And again, same thing, trustees take over and they administer according to your wishes. So there is a very strong overlap. And this, when I talk about keeping the maintenance, it's very important that when you do have a new account or you change employers or something like that, you keep everything updated. Ideally, in most cases, you want to have the trust be your beneficiary or the owner, and that way your trustees, they're ready to go. If something happens to you, they can get in there and administer according to what the trust says.
And speaking of trustees, many times we choose somebody in the family, but I think one of your slides said professional trustees. What is your recommendation on identifying who should be the trustee, or how, that would work?
Yeah. Well, my recommendation for people is number one, who are you leaving? Are they gonna, like if it's let's say a situation where you have minor children and minor children have one set of guardians and they're not the people that are caring for the kids aren't caring for the money, you want to make sure they're going to get along. Otherwise, that's a recipe for disaster, right? There are situations where we have to name together to jointly acting, but only in situations where we're trying to avoid something like an international trust. Never, never, never do I ever recommend having joint trustees. A lot of people say, "Oh, my two children, I don't want one to feel left behind, and I say, no, your kids probably can't agree on dinner. You're trying to get them to make huge decisions together. We're not doing that. You need to pick one that is very good with making logical decisions, savvy enough to maybe know where they need help. I need to maybe bring in an attorney, a CPA, right? Comfortable with that. But those are generally my guidelines on that. You don't want somebody that's going to be maybe not really good with making financial decisions, things like that. We want to make sure that that person is very logical in their thinking and is going to honor your wishes at the end of the day.
Yeah, I think everybody here either knows or has heard of stories of families broken up, people
Yeah,
feeling shortchanged. I mean, it's just, and it's sad, right? Because you've worked hard for your money and keeping it and growing it and building your nest egg for
yeah,
it to cause friction, what the
yeah.
last thing you wanted.
Right. And as I forgot to mention, so the professional trustees, those are available. They're professional fiduciaries. If we're at a place where we're just not comfortable naming anybody, there's nobody around to do that, or we just want to avoid everybody's going to fight and you know that, then a professional fiduciary would be. But know that they oftentimes have bare minimums that they will need, the state needs to have in order to accept. And it can be very costly. Mhm.
What kind of changes need to happen for you to update your original trust? Like new grandkids, new
Yeah.
property, what?
Yeah. So yeah, I would say major life events. If there's a major life event, definitely will probably need updating. The biggest one is like when your minor children are now adults, right? The provisions you would have put in there when they were minors, maybe you want to take a second look now that they're adults or they're, getting ready to graduate college or something. If they've gotten married, you may want to exclude their spouse for some reason. Maybe you want to add their spouse. Definitely if there's grandchildren, right? And that's a concern. Anytime that you have different property, and you want to may be very specific as to the gift of that property, that's also a good time. But everyone should keep their Schedule A, their schedules that go with the trust. Those should be updated, I would say at least yearly with your estate planning attorney, just to make sure. I know I send it out to all my clients at the beginning of the year, kind of gets them their mind jogging on, oh, we got this new car, we got this new house, certain things need to be updated.
Thank you. CDs and IRAs, which have beneficiaries, do these go through court?
They could potentially. Anytime that the trust is not named as owner, the door is open for a probate. Um, we hope not, but I will say, please, whatever you do, do not name a minor as a beneficiary on anything unless you want those funds locked in an account with nobody to touch until they're 18, or with somebody having to go file a guardianship petition over that minor's estate to access the funds. And a lot of people mean very well. They want to leave it to my kids. I'm going to name my kids, or I'll name all my minor kids. And they don't realize that now they've locked out grandma, grandpa, their spouse. Nobody can touch the money until we get a guardian petition in probate court for that adult to administer the kids' funds. So always want to make sure that it goes back to the trust.
All right. There's a number of questions on, inexpensive ways to be able to do this if you don't want to incur, legal fees. But so there's questions regarding online services like LegalZoom and Law Depot. And so they're wondering uh, if that's a good way and a, trusted source.
Yeah, I would be very, very, very careful. Again, no family is built one way, and what your documents, what you want them to look like, might be very, very different than your identical twin sisters. You've got different families, you've got different things going on. A lot of those automated, things. You're gonna get what you're gonna pay for. There's nothing like sitting across from somebody that is trained in the law and can see the loopholes that you might be triggering by just having a blanket, go to Staples, get a form and sign. Half of the stuff might not even pertain to you or your family. So I always err towards having this customized for you. Us ladies, we get our hair done. I would not expect to sit in the same salon chair and what worked for the girl before me work on me, right? We're different. We're different. We need that extra specialized what's gonna, care for you. What do you need? It is an investment, but I tell people, um, you pay homeowners insurance. That's insurance on your house. You pay car insurance. That's insurance on your car. These are expenses that as adults, we know we have to make. What bigger investment can you make on your estate, your family? So if you can, make the investment.
And speaking of making the investment, what is like a range that we can expect to pay to create a living trust?
Yeah. COVID honestly changed a lot. I'm seeing in my practice. Pre-COVID rates, you could find, $2,000 or $3,000 for a package. But right now, supply and demand, so about 4 or 5,000 is about average, I would say, depending on what county you're in, what state you're in. But yeah, it is going to be somewhere around there for like a basic package. I would say 3 to 5,000, you're probably fine.
Okay, perfect.
Mhm.
Somebody has a question, and please, if you're watching, you have a question, type it in. We're getting close toward the end, so please, let us know if you have questions. And Yvette, they're going to come at you fast.
Sure.
Somebody set up a revocable trust in Texas, but now they've moved to California. Is a trust from Texas valid in California?
I can't answer that without looking at that specific, that's very specific to, I don't know. Just legal disclaimer, my malpractice insurance will be very mad at me if I answer that.
All right.
But I'll say generally this, you want to make sure to cover your bases. You want to make sure your documents are going to be honored by the state where you're going to be laid to rest and you're going to have to face probate, ideally.
Thank you. You did mention irrevocable trusts were good to have. I know that that's a scary, situation for us, right? Because you cannot make any changes, but that is necessary, especially when it comes to Medicare or, Medi-Cal, Medicaid. So that's otherwise, your property could go.
Yeah.
But a question is, it sounds like we first need to set up a revocable trust and then eventually change it to irrevocable trust. Is that the case?
Well, it depends. So revocable is you're young, you're gonna make, it's gonna be you administering it, and when you die, it automatically becomes irrevocable after both grantors die or after you die if you're a single grantor. Um, remember, in revocable trust, that's still your asset because it's your trust. The irrevocable trust, you're relinquishing ownership rights. So it is no longer your asset. So I'm giving and I'm putting my house in here and somebody else is taking the keys. I'm legally now relinquishing forever my interest in this house. That's what part of what makes the irrevocability. So one does not automatically go into the other. But if it's a situation where I can't afford the extra cost of an irrevocable trust, then yeah, absolutely. At least start with a revocable one if you have real property.
Can the same attorney do one, transfer one from a revocable to irrevocable? Can it be the same attorney?
You mean if the house is in an irrevocable trust, can it go into an irrevocable trust?
Correct.
Yeah, it's the same as if you refinance or you buy another home. You can take it out of the trust, put it back in, take it out of the trust, sell it. It's fine.
Okay. Does a person and their spouse need separate trusts or can they be joint trusts? Can it
Mm.
be both in a joint trust?
Yeah, that's a good question. Most of my clients have joint because they don't want to pay to have two different trusts. But sometimes it makes sense for them to have separate trusts. If they're coming in, for example, like a blended marriage, and both of them have substantial real estate portfolios or substantial portfolios that they want to keep absolutely 100% separate, it may make sense in those situations for them to do separate ones if they have kids independently. There are situations, it's not uncommon, where they decide that that's what they want. But most of the time it's joint.
And I guess the question is regarding your trustees to
Mhm,
the trust. So many of us, right, if we have a spouse, usually it's the surviving spouse.
mhm.
But the question is, what if both people pass away in an accident?
Yeah. If both pass away, then it would go to your successor trustee. So it may be, both grantors are acting trustees, both of them are gone. Then who did they leave as a number two or a number three? Always good to have at least 2 to 3 successors in case that happens, in case multiple people die at once, or you get to the successor and they're like, I don't want to do it. It's too much responsibility. Then you have somebody else that's named so the court doesn't have to step in and name someone.
Mhm.
Yeah.
Good. So good to have a number of trustees and
Yes.
perfect.
Mhm.
Here's a question. Somebody has artwork they purchased a long time ago and has greatly increased in value. Is there a way to sell the artwork to avoid large capital gains? Would the trust be able to help with that?
Mm. Uh, so that's a really good question, and we're seeing this area change a lot with crypto and stuff like that. But capital gains is really limited still to just like the liquid sort of assets. So your stock, your bonds, your house value, that sort of thing. You definitely want to get an appraiser involved with the artwork and definitely have that named in the trust specifically if it's something that's of such a big value. Yeah.
But they would still incur the capital gains, have to pay that if they sell it after.
I would say talk to your tax professional about capital gains on intangibles like that, like a art piece or something like that. Yeah.
Okay. Um, you mentioned this before, but do you need to have a will and a trust? I know you had the
Hmm.
visuals and
Yeah. So one thing, and I apologize if I didn't make this clear, is whenever we do a trust, right, the good, better, best option, right? We always will always still do a will. And it's now not a standalone will, it's called a pour over will. Meaning if you forget to put something in your trust, you buy other stuff, and for some reason we end up in probate court, it lets the probate court know there's a trust and your intention was for everything to pour into the trust. So we do it more as a safety net, but not as a standalone document. And the other reason we still do it is to name guardianship designations for minor children. So if you have a will, it's standalone, good, better, right? But if you have a trust and you go for that best option, you will still have a will. It's just that it won't be on its own standing alone.
all right, here's a question. Is your trust filed somewhere at a state level? Somebody
Mhm.
has a question that, the law firm closes, you can't find your lawyer.
Mhm.
What happens to your trust? Okay,
Uh-oh, I think
there
you
you are.
froze.
Yeah,
Or
no,
maybe
no,
it was
there.
me.
Yeah.
Okay. Um, yeah, that has happened. I've heard of this happening before. So your trust, you go back to what I shared, it's private. You don't want it out there in public records anywhere. A lot of people get confused because when we fund the trust with your home and we list the trust as you as trustee of the trust as the new owner, that new deed gets recorded. but we're not recording your trust itself. So no, you're not recording the trust anywhere. I always advise my clients to work with somebody that will do electronic version copies for them. I know my firm does it, so that you can have an electronic copy if it goes missing, something like that. And that way your people can also have one in a lockbox or whatever USB drive that they can easily access if that is to happen.
Right. So if you don't have it, your attorney's gone, the law firm's gone, you have to start again.
Yeah, we get emails
Yeah.
all the time, like on our
Yeah.
listservs, of people so and so we're looking for this person's trust, and
Yeah.
sometimes somebody is able to come. Maybe they've bought the practice of that other attorney or something, and they'll have it, but sometimes it's not.
Perfect. And I really want to thank everybody who joined us today because, you're doing some research, but I also want to mention that AARP has online resources that provide information. So, of course, you can find information on financial resilience resources and events at aarp.org/let's talk dinero. Once again, that's aarp.org/let's talk Dinero. Yvette, we're getting close to the end. Any quick final comments that you have?
Yeah, I think that visual hopefully will be imprinted for most of you just to know the differences between them. Again, it is an investment, but just like you insure your house, your car, right? This is something that you just got to do, especially if you own a home. You already know the costs that are going to be involved. So just do it, work with somebody. And there's lots of resources out there. Like you said, AARP has some. The state bar has some. They also have lists of attorneys local to you and wherever you are that can help you. Nowadays, everybody's virtual, so that might not be a thing. But always, whenever you are going to work with an attorney, always look them up and make sure that their license is valid in whatever state and they don't have disciplinary practices against them. And lastly, please be cautious of people that are not attorneys trying to pose as attorneys or trying to give legal advice. That is very tricky. Again, this is an area where just do your homework and look up the people that you're working with.
Perfect. And continuing your learning journey, join us on Monday, January the 27th, 2025 at 4 p.m. for our next Let's Talk Dinero with AARP event. Once again, January 27, 2025 at 4 p.m. That's when we're going to have another chat. And of course, if you missed any part of this, you can view this video later at aarp.org/let's talk dinero. We've been featuring, you'll also find videos of experts talking about debt management, investing, retirement planning, entrepreneurship, and lots more. So you can view this one and other discussions. Again, of course, Yvette, thank you so, so much for this information. We were overwhelmed with questions, and I apologize if we couldn't get to all of them, but you can view this video later on. Some of the questions that were being asked were covered on the video. So don't be, shy, look it up. Thank you. Remember that AARP is here to help you with resources and events to help you choose how you live as you age. Yvette, mil gracias. Thank you so much.
Yes, my pleasure. My pleasure and honor. Thank you. And yeah, if I didn't get to your specific question, I did put my contact information in the chat. People can feel free to reach out to me, and my firm will happily answer the questions.
Thank you to everybody. Feliz Año Nuevo, Happy New Year, and see you Monday, January the 27th, 2025. Bye, everybody. Thank
Bye.
you
Happy
all.
holidays.